Well, good evening, everyone. Hope you're all doing well. My name is Dave Bambry, and I serve as the Vice President for Alumni and Student Engagement at your University of Illinois Alumni Association. I first want to thank everyone for joining us this evening, as we're looking forward to another great session of our ongoing Alumni College Speaker Series. Before I introduce our speaker this evening, I always like to remind everyone to please feel free to submit questions throughout the presentation through the Q&A feature at the bottom of your screen. We will do our very best to get to as many of those questions at the end of the presentation as possible and have left time to do so. I would also encourage everyone, if you haven't done so already, to visit Illini Link, one of our newest initiatives at the Alumni Association. Illini Link is an online networking and mentorship platform that allows alumni to connect and help students while also being able to interact with fellow alumni. Whether you have just a few minutes or many hours to spend with Illini Link, I think you will find it to be a great platform and resource. You can find this by visiting allinilink.illinois.edu. But let's get to why we were all here this evening, and that is to hear from a wonderful faculty member from the University of Illinois. And it is my distinct pleasure to introduce our speaker this evening. Suja Thomas is the Peer and Sarah Pedersen Professor of Law at the University of Illinois College of Law. She wrote The Missing American Jury, Restoring the Fundamental Constitutional Role of Criminal, Civil, and Grand Juries, Cambridge University Press, and co-authored Unequal, How America's Courts Undermine Discrimination Law, Oxford University Press. She's appeared on CNN speaking about juries, and her work has been featured in the New York Times, Wall Street Journal, and Slate. Professor Thomas is making a mainstream social justice documentary film and was a fellow in the Cartemquin Films. He graduated from Northwestern University and NYU Law School and practiced law in New York City prior to coming to Illinois. With that, and without further ado, it is my distinct pleasure to bring to you Professor Suja Thomas. Suja, thank you so much for being with us again. And I know that we're all looking forward to a wonderful presentation. So at this time, I'm going to go ahead and kick it over to you, and I'll be back in just a little while for the Q&A.
Thank you, David. It's my pleasure to be here today, and I'm going to share my screen right now and have all of you see this presentation. And so it's really nice to be here to talk to you about my documentary film, Justice by One. The Fall of Juries is the topic of the documentary film. And so a lot of us think of justice as being accomplished by people from a community. That is, people on juries, 12 people on a jury deciding critical questions such as who goes to prison, whether civil rights abuse has been committed, whether when you have a consumer who has a dispute with a company, that juries decide those issues. But instead of juries deciding, almost invariably, one person in our system is deciding, and that is a prosecutor, a judge, an arbitrator, or a police officer. And so in this film, what I'm trying to do is call attention to this issue and hopefully create a motivation for change. So what I want to do today is I want to start with telling you how I got to the point of being a lawyer first, a law professor, and then making a film, actually being a filmmaker. And so I'm going to tell you the path to why I'm making a film. And then I'm going to show you a demo reel, which is a sample of some of what we have from our filming. We're just starting to put together the actual film, but I wanted to put something together so all of you could see a little of what we've actually have in terms of footage. So let me just start by saying that, you know, this all started some time ago in the 90s when I worked for this employment discrimination firm. So after I clerked in Chicago for a judge and then worked at a big law firm representing companies against companies, I went to this small discrimination firm where we represented plaintiffs in discrimination cases. And I got really lucky. The first day I went in there, they were like, we have a trial and you're going to be on it. And the trial, the case was representing an African-American man who accused his employer of discriminating against him and retaliating against him. And he had alleged that he should have been promoted He came into the company, it was a bank, with a group of people, and everyone other than him and the other African-American person in the group had been promoted. And so he complained to the HR department about this, and they said, you know, you're gonna get promoted in time. But again, everyone else had been promoted who was white. So after he complained, he started having actions taken against him. And in fact, soon thereafter, he was actually terminated. And so he brought a case alleging discrimination and retaliation, and the case went to a jury trial, like I said. And when we presented evidence to the jury, and there were capable lawyers on both sides, and we won the retaliation claim. And so the jury said, yes, our client had been retaliated against for complaining about discrimination. So the jury awarded back pay, which is money that you get when someone's terminated, and then the time until the trial. And then he also got an award of compensatory damages, which is emotional distress for what he suffered for being retaliated against. And so the jury awarded $219,428 in emotional distress. And we were happy. He had gotten what we thought he deserved. And then the employer said, well, that's too much. A reasonable jury wouldn't have found $219,000 in damages. In fact, it should only be $20,000. And so the judge agreed with that. And the judge said, take $20,000 or take a new trial. Now, we ended up settling that case, but most people actually take the reduced amount, the remitted amount. So the term of this procedure is called remittitor, because if you can imagine going to a new jury trial, that would cost money, and you actually have the same judge. So the judge has already said the maximum a reasonable jury could find is $20,000. So even if you got the same dollar amount or even more, the judge is going to reduce that to $20,000. So most people, I did a study of this, and I'll talk to you about this in just a minute. That study actually showed that 77% of people actually took the dollar amount that the judge ordered. So instead of a jury trial, he essentially had a judge trial where the judge decided what the dollar amount should be. And so, and the jury was a diverse jury, and the judge was one person, you know, one race, one sex. And so I was shocked by that. I thought that didn't make sense to me, that if there's a right to a jury trial, why should a judge be able to change this verdict? So another case also sort of changed my perspective on the legal system. And that was a case where we represented a plaintiff in a case against Columbia University. So our client was a Columbia University professor. She had this amazing record. She actually went on to win the MacArthur grant. It's called the Genius Grant. Some of you may know about this. And she had this, like I said, an amazing record. And she was of Pakistani origin and also Muslim. And decision makers on her tenure included two main people who were Indian and Hindu. And some of you may know that there can be conflict between those religions and those countries. And so the people from Columbia had made some explicitly discriminatory remarks against the professor who was up for tenure. And despite all of that, the judge in the case said on a paper record, no hearing, that that's not enough. I don't think there's sufficient evidence to go to a jury trial. I'm going to order a summary judgment. Columbia wins. And so she decided a reasonable jury could not find for the plaintiff, our client. So the case was dismissed. Again, I was shocked. Why could this very factually intensive case be decided by a judge when there in fact is a right to a jury trial in the Constitution in civil cases? Okay, so next I became a professor. I wrote these articles. One I mentioned before on remittitor, where I did this empirical study of 10 years of the courts deciding cases that were remitted, and found that it was used more in civil rights cases, and also found that people took the remitted amount. But I also studied historically whether this procedure existed, and then I also looked historically at whether summary judgment existed in this other article. And the reason I looked at that was that the jury in the United States was based on the English jury. And that jury was this very vibrant jury. That jury decided lots of cases. And the United States Supreme Court has actually said that when we look at the jury trial in the United States and we look at what power the jury should have, we have to look to England, which is the jury on which our jury in the United States was based. And so when you look at that, and I did the studies, I found that these procedures didn't exist. And so I have argued over the years that these procedures are unconstitutional. So that's on the civil side. I also became interested in the criminal, on the criminal side of things. And so plea bargaining, many of you may know, is when a prosecutor says to a criminal defendant that if you plead guilty, you'll get much less time in prison. But if you don't plead guilty and you go to a jury trial, you'll get much more time in prison. So I want to tell you about a case called Boerdenkircher, which was decided by the United States Supreme Court in 1977. The Boerdenkircher case, along with a couple of other cases by the United States Supreme Court, really affected the state of plea bargaining today. 97% of people plead guilty. And I would assert that it's that high because of the trial penalty that I referred to before. And I'll give you an example of that happens here in Boerdenkircher. So in Boerdenkircher, there was a guy named Hayes, and he was accused of forging a check for about $90. And the prosecutor said to him, if you plead guilty, you're gonna get 5 years in prison. But if you don't plead guilty and you insist on going to a jury trial and you're convicted, you're gonna get life in prison. Well, Hayes was like, I'm not taking 5 years for a forged check of $90. I'm going to a jury trial. He went to a jury trial, he was convicted, he was sentenced to life in prison. So he goes to the United States Supreme Court, very difficult, as you all know, to get there, but he gets to the United States Supreme Court. In a 5-4 decision, the United States Supreme Court says that this is constitutional, that plea bargaining is an important part of our criminal justice system, and that this is constitutional under the Fifth Amendment and the Sixth Amendment. Again, a 5-4 decision. So in this book that David mentioned, The Missing American Jury, I argue that these different procedures that I've just discussed, remittitor, summary judgment, plea bargaining, are problematic constitutionally. They didn't exist historically, and they've taken away the authority of the jury. And in fact, on the criminal side of things, really is this coercive weapon that is used by prosecutors. The second book I wrote, Unequal, with my co-author Sandra Sprino, who's a University of Illinois law grad, that book calls attention to the fact that, like the Columbia case, there are lots of cases with very, very explicit facts of discrimination that get dismissed before trial, where a judge will say a reasonable jury could not find for the plaintiff. One of the things that I've done with my research is always tried to reach out to courts to try to get them to think about the arguments that I have made in my articles and my books. And so I've gotten some, I've had some conversations with different judges. Some of them have cited me. Some of them have given me book blurbs. And I even had a conference where Justice Scalia was the keynote speaker. Justice Scalia was a real big fan of the criminal jury, and he used history to make sure that the criminal jury actually had its authority that was intended. And so he was an interesting person to interact with, and I interacted with him also on the summary judgment issue, and he read my article and found it persuasive. I've also done work where I've testified through written testimony to Congress. I've also worked on legislation with advocacy groups like the NAACP Legal Defense Fund and the National Women's Law Center, as they've tried to make changes to the law that's hurting juries from not deciding, or basically preventing juries from not deciding, or from deciding cases. And I've done op-eds, and one of them was with Mark Cuban. The jury has been taken away from lots of SEC cases, and so I wrote an op-ed that I asked him to sign on to, which he did. I wrote a couple of pieces also around the time of Me Too about what I talked about in that Unequal article or book, and also in some of the stuff that happened in my practice, that is these cases being taken away from juries before trial. And most recently, I did a TED animated video that has about 600,000 views. And I did all of these things to try to get people to think about how change should occur, because the system isn't what it should be. That is, it was intended that juries were supposed to decide, and instead now we have one-person decision makers. So because I haven't been successful thus far in making this change, I have embarked on a documentary to try to expose this issue to the public, to try to then motivate change. And in the documentary, I feature several characters. I talk to a lot of experts, and I talk about remittitor, summary judgment, plea bargaining, and I also talk about arbitration, which I haven't mentioned thus far. Many people are subject to forced arbitration in employment, and all of us are subject to forced arbitration in consumer agreements, such as credit cards, cell phones, and the recent Amtrak accident, the terrible tragedy in Montana. Those folks are all subject to an arbitration clause that has to be arbitrated, and they have to be arbitrated on an individual basis. The last thing I want to say is we're fundraising. We could really use your help if you're interested. I've raised over $200,000 so far. The part that we're in right now, post-production, it actually costs quite a bit. The editing, the music, the footage that we don't own, the color correction. So if you're interested, if you think this is an interesting project and you'd like to donate, you can get a tax deduction by donating through the University of Illinois Law School. I think Casey put in the chat a link to what giving, and then you actually, Casey, I guess you could write on there that you have to scroll down to Professor Suja Thomas Documentary Fund. So you can go on that link and scroll down to Professor Suja Thomas Documentary Fund. So love to get your support if you want this film to be made. That's my last pitch. And yeah, I'd love to answer any questions that you have.
Suja, thank you so much, and thank you for the sneak peek into the documentary. It looks like it's coming together great, and I know we'll be anxious to see the final product once that's available. But yeah, definitely encourage folks to go ahead and drop their questions in the Q&A function at the bottom of your screen, the Q&A tab there. I know we've got a couple questions already, but certainly want to try to get to as many as possible. So definitely feel free to drop questions into the Q&A at the bottom of your screen there. We do have one question here, and you mentioned some statistics earlier about the percentage of cases that actually go to trial. We had a question asking what kinds of criminal or civil cases are included in your low percentages. Are small claims cases included, or traffic cases, those types of things? Those are obviously very small numbers, so just a little more into that if you could.
Sure. So the statistics that I have are only statistics that include cases where there is a right to a jury trial. So for example, in criminal cases, there are some criminal cases that involve not much time in prison or no time in prison, where there wouldn't be a right to a jury trial. And so the statistics wouldn't include those cases. And then in terms of civil cases, again, there are only certain cases that have the right to a jury trial. And generally under the Constitution, the 7th Amendment, it's monetary damages, but that hasn't been followed that closely. It actually says $20 in the Constitution, but it hasn't been followed that closely. So there are some small claims matters that they've said there isn't a right to a jury trial. I don't agree with that. But anyway, the stats don't include those.
Great. We had another question come in and ask you to maybe talk about what you see as the path to change. So do you envision legislation at the national level, state level, maybe something else that you see to help change this?
Yeah, I definitely think that legislation is the path to change. I think that it's unlikely, very unlikely, that the United States Supreme Court is going to revisit its decision in the Bordenkircher case, for example, and say that it's not okay to tax someone for taking the jury trial. So I don't think the United States Supreme Court is going to change things on that side. And then on the civil side, even though, again, I think there are incredible arguments to say that summary judgment and remittitor are problematic, I think that the United States Supreme Court also isn't going to do anything there. I will say that even Justice Scalia, when he wrote me a letter saying that he thought my arguments were persuasive, he said, I don't know what I can do about it. And I was going to say, well, yeah, you could do something about this. You could lead the charge. But so I do think legislation is the way to go. I've talked to a couple of senators' offices. They've seen the video and they have said, bipartisan support is really important here. And so I hope that that's something that can really, that the film can really get people on both sides of the aisle to think about these issues. And something else I was going to say here. Yeah, but anyway, I was going to say that on the criminal side, one of the things that could happen, I don't think we're going to get rid of plea bargaining in my lifetime, but in other countries, in some other countries like England and Wales, there's a cap on the penalty for going to trial. And as much as I think it's just not right to be penalized to go to trial, other countries do have a cap. And I think that that's what we need to do immediately is say, it's not right to say with Robert Davis, he was literally going to get 40 more years because he was going to get life versus getting out at age 41 when he was 18 initially. So he had 23 years versus life. And it was a 40-year tax. For Rodney Roberts, the person who was on the bike, it was a 60-year tax. In terms of like how old he was and what the situation was. So in any event, if we were to legislate and limit the cap, that's one of the many changes that we can make to change the system. There's lots of discussion about forced arbitration right now, lots of hearings that are going on. And one of the people we're featuring actually testified a couple of weeks ago. Her name is Glenda Perez. I don't know. I mean, I don't know. We've been talking about changing a forced arbitration for a long time. I hope it can change with this round, but I'm hoping the film at least will call attention to the problems.
Absolutely. So we had a question come through on asking about if you do research on cases that do go to trial. So obviously the defendant is hearing, this huge number, life sentence or many, many years in jail if they're convicted. Do many juries actually take it to that maximum, do you find? Or, is that more speculation and they get a much lesser sentence if they are found guilty, if they do decide to go to trial?
So I haven't done research myself on kind of those cases that go to trial, but anecdotally, what I have heard, obviously the Bordenkircher case is an example of that. And sometimes what happens is you get charged with something that if you plead guilty, they'll charge you with this. And if you don't plead guilty, they'll charge you with this. And sometimes there's a, quote, mandatory minimum that the judge has to impose. And so it becomes very difficult for a criminal defendant because that's it. And it becomes very difficult for a judge. And so I've interviewed lots of judges who have talked about how they're stuck. They're stuck because the prosecutor, they'll actually say this, they've said this, the prosecutor controls everything. One of the things that's been really interesting to me is I'm going a little off the question, but I started this film thinking that it was the prosecutor who was the most important person in the criminal justice system. I'm now at the stage where I've decided that the police officer is the most important person in the criminal justice system, because everyone is telling me that the prosecutors rely on the police report. You know, almost invariably, there's no investigation that's independently happening. They rely on the police report. And so if you're doing these plea deals based on the police report, then the most important people in the criminal justice system are the police.
Absolutely. So we got another question here. Admittedly, they say their experience with jury duty is limited, but it seems to them that juries tend to be less reliant on the rule of law and more on personal beliefs, which in this society might be even worse. Is that your experience? And they go on to say, do you believe in professional juries?
So I'll answer the latter. You know, first, I don't believe in professional juries. I believe in the Constitution. The Constitution gives the right to a jury trial and gives juries from the community the right to decide cases. So I believe in the Constitution, and that's what, you know, we have right now, and that's why and then I also think, I will say in my book, I do this whole constitutional analysis, but at the end I say that in fact, I show that in fact juries are the best decision makers. But I'll also say that judges have said to me over and over again that juries get it right. They say it over and over again. So if you talk to a judge, I can guarantee you that the person who asked the question, they will tell you that juries get it right. Yes, every once in a while, a judge will disagree with a jury. But almost invariably, judges will tell you juries get it right, and juries actually appreciate their service thereafter. Anecdotally, well, I actually was on jury duty this week, which is funny. I think I didn't know, there were no juries. I think there were no, I mean, I certainly didn't, we didn't get to go anywhere other than the jury room. And then we just were told to go home and check our emails, and didn't get called in. So consistent, obviously, with very few jury trials. But one of the things that in the orientation the judge said was, he said that people always talk about their jury experiences. And my anecdotal experience with that is I have a twin sister and my husband, both of whom have been on juries, and they talk about their jury experiences, that they were very important to them. So I also think, separate from the right to a jury trial, I think having all of us participate in this process is really important to our growth as citizens.
So I'm going to take a liberty here. We have two questions that are very similar, so I'm going to try to combine them both up, and apologies to the two folks that sent them in if I'm not getting to 100% of their question. But they say, on a practical level, could our system really manage an increase in juries? It seems like it takes an extremely long time, even in our current system, to prosecute cases. So, you know, would increasing the number of jury trials actually be practical in our current state?
Yeah, I think that is certainly that is the comment that I get most when I talk about these issues before different groups of people, and oftentimes a lot of people in the system, that is prosecutors, judges, will comment that the system couldn't handle it, or law professors will say this a lot to me when I've spoken to law professors. What I would say about that is that we have a lot of research for a lot of things in this country. And if we're going to criminalize, for example, I'll take the criminal justice system first. If we're going to criminalize matters, things that people do, and we have a constitution that says that we need to look at these, the people who are accused of crimes, and let them have a jury decide before their liberty is taken away. You know, that separates us from a lot of other places in the world. And so we have lots of money for lots of things. And I think that we definitely have enough money to have more jury trials. I don't think everyone's going to take a jury trial. If you change the system and you make it more fair in terms of pleading guilty, I think some people will plead guilty because they don't want to necessarily go through a trial. Yeah, it's going to take more resources, but we'll shift resources to this and away from other things. And I think that's right. I think we have a very unjust system right now where people are thrown into prison without anyone looking at it. And I think that is not what the United States was supposed to be.
Thuja, have you seen a shift in the numbers over time, or is that something you've studied at all? 20 years ago, was that number of jury trials drastically different? And if it was, do you speculate as to why?
Yeah, and I've been mainly talking about the criminal justice system, and I'll say this about the criminal justice system in particular. But with the criminal justice system, there have been kind of these different points in time. And after the Civil War, there was an increase in plea bargaining. After World War II, I believe, there was an increase in plea bargaining. And then in the 70s and 80s, there was this creation of these mandatory minimums, and then sentencing guidelines followed. All of these things have contributed to making it much easier for prosecutors to say to criminal defendants, if you don't plead guilty, you're going to get this drastically different sentence if you are convicted before a jury. So that's what we've seen in an increase over time. Yeah, so we have seen this increase over time in the criminal justice system, and that is a decrease of the number of juries. And then on the civil side, there aren't, the stats weren't kept, sort of in the way that we would love, I think. Certainly, there's a number of factors, including settlement, which I don't think there's a problem where people settle a case instead of going to a jury trial. I do think it's a problem if you settle a case because you think it's going to get thrown out by a judge on summary judgment. So some of those cases that settle are going to be affected by that. And of course, if you don't ever get to a jury trial, it's going to cause the stats to increase, that is not have as many jury trials. So the answer to your question, David, is yes, we see a decrease at different points in time, but some statistics on the civil side, we don't have as many statistics.
Thank you for that. We got a question in the chat here about criminal cases specifically, and asking if the defendant has lawyer representation, what sort of advice does the lawyer give? Do they really advise pleading guilty, and if so, why?
Yeah, I love that question this week, particularly because there's a person I'm talking to about possibly featuring their case in the film, and they actually had a case where they took the case to a jury trial and they won, and it was a self-defense case. Lawyers are in a very difficult position. And mostly, it's a lot of public defenders, and they're a very difficult position because there's even some case law that talks about, the requirement that you kind of advise your client, of course, about the drastic result that can happen if you actually go to a jury trial. So defense lawyers are in a very difficult position in terms of advising their clients. I think this is problematic if someone's innocent or not innocent, this system. The people that we have in the film, they're innocent. But I think it's a problematic system regardless, because we don't have any testing of the system. We don't have any testing of the prosecutors. We don't have any testing of the police. And that is not good, I think, for our justice system. Did I completely answer that question?
Yeah, I think so. I mean, I think you talk about, why they kind of advise that, and
I wanted to tell you. Oh, this is what it was. I wanted to tell you more about the case. So the case that I'm thinking about featuring is a case where the person ended up taking out a gun and having to shoot someone, and it was self-defense. They alleged it was self-defense. And they were charged with manslaughter, and they would have gotten, it was life versus, I think it was 13 years, if I recall, and he was 30 years old. I'm just at the beginning stages of looking at this case. And what they did was they actually there's a speedy trial requirement, and everyone waives the speedy trial requirement. And then they get, if they are thinking about going to trial, they get, especially get the what's called the Brady material, the exculpatory, the material that prosecutors are supposed to have that possibly could be exculpatory, that is show that the person didn't do it. And so they waived their right to this, or they basically waived their right to the Brady material by saying, I'm not going to waive my right to the speedy trial. So they went to trial without anything. And they did this trial and they won before a jury within, it was less than 90 days. And it's an extremely unusual situation. And she said to me, one of the lawyers told me that people just couldn't believe it, right? That they were doing this. But this criminal defendant was saying, I'm innocent. This is a self-defense case. There was no reason for me to shoot him other than the fact that he drew a gun and I had to shoot him. And so that was the kind of unusual case that I heard about this week, where there was a jury trial that we're considering putting that in the film. But it is a very difficult decision for a criminal defendant, and very difficult for defense lawyers to advise their clients otherwise.
Absolutely. So flipping the script a little bit, if you talk to jurors along the way, I'm just wondering kind of how those conversations have been. Do they feel equipped to be making these decisions? I'll speak personally. I've never sat on a jury, but it strikes me as a bit of an unsettling feeling when you're being asked to make this life-altering decision for something that you may have not had, much knowledge or education on before you've stepped in the jury box. So just wondering, kind of if you can maybe talk a little bit about those conversations.
Yeah, so that isn't something that I've done. I haven't talked to jurors. There is a project called the Civil Jury Project at NYU, and they've talked to a lot of jurors, and I'm going to use their information because they had sort of access. What I know so far is that for the most part, I think people do feel equipped because they're getting instructed on the law. They can ask questions, they can take notes. It is interesting, my own perspective of thinking about being on a jury. It really was this sort of heavy weight on me that I thought, wow, if I get picked for a criminal trial and I have to decide that person's fate. So it was interesting to have it flipped on me that I'm actually was in that position of possibly being on a jury this week. So I certainly get it as to the importance and whether or not I'm equipped thinking about those issues. But I do think for the most part that people are feeling like they're equipped to decide most of the issues that are put forth before them.
Absolutely. We had another question come in. They said they get the impression from judges and police in regard to this issue that they don't really care that much about the people they're affecting. They want to get a confession so they can avoid a bunch of work and be home at 5. Have you gotten that impression, and do you think that's a true statement?
I don't, I can't comment on whether or not they want to be home at 5, but I do think that this justice system has just gotten accustomed to, we have a police officer on the street most of the time coming after the incident occurred, making a report based on what different witnesses say, but not necessarily deciding to talk to everyone or even talk to the person who is accused in a way that is fair. Prosecutor then relying on that police report because they're feeling like they don't have enough time, or they just want to keep moving cases through the system. I don't know how hard everyone works. I'm assuming people, work as hard as they're supposed to be working. But I definitely don't think that we should be churning cases through the system and just relying on these police reports that are not supposed to be the end all, and how could they be? You're just on the scene talking to people. You're not talking to everyone, and you don't know all of the facts. I mean, you can try to put it together, right? And that's great that they do their job trying to put it together, but that can't be the end all. And that wasn't what the Constitution wanted us to do, for sure. It was that the jury really got to see everyone, talk about everything, and present it all before us, and have a jury decide beyond a reasonable doubt, right? You have to have 12 people. So one of the things that's really interesting is that, formally we had 12 people on a grand jury, and we had another 12 people on a jury, a pennant jury. And so a total of 24 people had to say a person, probably did something wrong, or beyond a reasonable doubt did something wrong. 24 people. Right now we have one person standing away of someone going to prison. And I think that's not where our system was supposed to be.
Absolutely. We've got time for just maybe one or two more questions here. We had a question in the chat. So they've heard that there's a large amount of conflict of interest in arbitration. Specifically, many arbitrators may have cozy personal relationships with companies that they're arbitrating for consumers. Oftentimes, plaintiffs do not know of these relationships. Can you talk more about this? Is this problematic? Is this something you've seen?
Yeah. So you have foreshadowed what is actually in the film. So unfortunately, we have a case where the arbitrator was good friends with the lead lawyer on the case, and the plaintiff was not told that. The arbitrator should have told the plaintiff that. Instead of having a hearing in that case, they actually used that procedure of summary judgment, and the arbitrator ordered summary judgment against the plaintiff. The plaintiff was stunned, didn't understand how this could be. The hearing was supposed to be a week later, and then did some Googling and found a picture of the arbitrator and the lead lawyer, and tried to challenge it, and wasn't successful in the courts. And I think that, again, is problematic, that the courts thought that this was okay. So we'll be featuring that in the film, and we're excited to be including that.
Absolutely. And maybe time for just one more here. I think you may have touched on this a little bit, but there have been obviously a lot of high profile court cases, jury cases, in the news and on TV recently. How do you think that affects this? Do you think that people may be more or less prone to take a jury trial if they, if they do find themselves in that situation, or is this just something that, is part of what we're doing moving forward, and you think the numbers will, kind of stagnate here and stay the same?
Yeah, I don't think where you see a few people take a jury trial here and there, I don't think that's going to affect people because they face the trial penalty. Many judges have said to me, and I'll include this in the film, they've said they'd plead guilty if they were innocent, because they if you go to a jury trial, you're convicted, you're going to be penalized, by life in prison, or 20 more years in prison, or 10 more years in prison. So I think that even though some people are, take a jury trial, I don't think that that's going to affect people, because they're the ones who are going to suffer in prison for longer. And someone might say, "Oh, I just take the jury trial because if I'm innocent, I'm innocent." Well, you see what happened in Robert Davis's case. There's an interrogation, that lasted 6 hours, and they shouldn't have done that, and they wouldn't have played the 6 hours of interrogation. So there was wrongful conduct, and that's often what happens. And one of the things that they did during that interrogation is they lied about DNA evidence. There was no DNA evidence. He'd never been in the house. And he said that it doesn't make any sense. And they said, "Oh, we can't lie about DNA evidence. We can't lie," which of course, they can lie. And so I think that criminal defendants are put in very difficult positions. Again, I'm not saying everyone's innocent. I want to be clear here. I'm not saying everyone's innocent. That's not the case. But I think a highly functioning, good criminal justice system will have a number of trials to continue to test the system.
Suja, we're at the hour mark here. I want to certainly respect everyone's schedules, but thank you so much. This has been absolutely wonderful. I think we could probably go for another hour, and you know, maybe we should do that at some point. But I wish you the absolute best of luck with, you know, the rest of your film. I will go ahead and mention again, if you do want to support Suja's work and the documentary here, we've dropped that link in the chat. Definitely go on to the website. Make sure you hit that drop down menu and pick the Professor Suja Thompson Fund, and you know, obviously give if you can, and if you would want to do that and have the means to do so. But Suja, thank you again. Can't thank you enough for spending this time with us. Just one other note before we leave here. I did want to mention we do have another session coming up. Actually, Chancellor Robert Jones, Chancellor of the University of Illinois, is going to join us on December 13th at 6 p.m. You'll be receiving some email marketing in the very near future about that session, and you can get signed up. He's going to talk about really a kind of a year in review. It's been obviously a busy year at the University of Illinois. Every year is, but especially this year. And he'll have a chat with our colleague and friend Robin Kaler, who is the head of PR and marketing at the University of Illinois at Urbana-Champaign. But again, thank you so much for joining us. We can't thank you enough for spending this time with us. Hope you all have a wonderful holiday, and we look forward to seeing you in December. Thank you so much. Take care.